Lords, I was dealing, when we broke yesterday, with the payment of adverse costs, or more particularly the licensing of adverse costs, and I dealt with most of the points I wanted to make on the wording. There is a point taken perhaps both ways on the origins of the legal fees exception or licensing ground, and you'll find that in the EU rules as far back at least as 2003, and that's in Regulation 881 of 2002 at Authorities Bundle tab 3, please, if I could show you that, which I don't think we've yet looked at. And if you go to page, it starts at 569, these are directed at terrorist sanctions, ISIL and Al-Qaeda, but the wording is, well, this is the origin of the exception, and the wording is then mirrored as one sees later in the subsequent regulation. So at 589, your lordships should have Article 2A, which is inserted at some point, and it says that Article 2, which is obviously the freeze and the prohibition on making available, shall not apply to funds or economic resources where A, any of the competent authorities of the Member States has determined on a request made by an interested natural or legal person that these funds or natural or economic resources, and then little 2, are intended exclusively for payment of reasonable professional fees and reimbursement of incurred expenses associated with the provision of legal services. Now the point, so that appears to be well, certainly the earliest example, I think, in the bundles you have of the EU exception, or licensing ground, I should say. You'll see, the point I make on this is that under the original rules as they were conceived, the ability to apply to use funds to pay reasonable fees was given to any interested natural or legal person. It was not limited to the designated person themselves. And we say that implies that anyone can apply for legal fees for any reason, but it certainly means you cannot imply, I would submit, from the origin of the provisions that the costs, the legal fees in question had to be those of a designated person, because otherwise it wouldn't say what it said. Now, my learned friends say, first of all, that the reference in the second part of little 2 to reimbursement of incurred expenses suggests that it was only intended to capture payments by a designated person's own lawyers, or sorry, to a designated person's own lawyers for their own fees, which they have incurred. But in my submission, that doesn't follow at all. Firstly, obviously, reimbursement is only used in the second clause, so it doesn't have anything to say about the first clause. But secondly, that is apt to cover the situation my learned friend posits in adverse cost situations, which is where the the party receiving the costs has already paid their legal fees and wants them reimbursed. So if that's the point, it works in any event. But in any event, if any interested person can apply for a license under this exception, and my learned friend says, well, that suggests that it's meant really only to apply to the designated person's own lawyer applying for his or her legal fees, and that again suggests it was always limited in the way he says the regulations now are. But my lords, there's nothing in this regulation to suggest that could possibly be a restriction on any interested natural or legal person. It doesn't exist in relation to any of the grounds, and it may well cover a lawyer who is trying to get paid fees from a recalcitrant client, although it would be, well, who knows, it may well include them, but it's clearly not so limited. And we say that is therefore some support for the idea that when the English legislature failed to restrict to only the costs of a designated person, but did in fact impose similar limitations to other headings like 1 and 3, there was a deliberate decision at least taken to keep 2 as wide as it is. And that applies therefore to all costs in both directions. And in any event, as you know, we say that that must be the interpretation if it's to be consistent with the right of effective access to justice. And I won't repeat that. My learned friends also say, in the context of the legal services licensing ground, and just for the reference, in case you don't still have it open, it's at Schedule 5, Paragraph 3, to the regulations in 2019 at page 1255 of the bundle, tab 16, 1255. You'll recall, I hope, that it says that it's there to enable the payment of reasonable professional fees and reasonable expenses. My learned friends say that the reasonableness requirement only makes sense in the context of a designated person's own costs. That's their skeleton paragraph 85, and we say that's not so in a litigation context at the very least, because of course, my lords, cost orders in litigation in either direction are only made in respect of reasonable costs. So the court will already have considered the costs to be reasonable before it imposes the order, and it may well be therefore in a litigation context the reference to reasonableness is surplusage, if you like, or is not necessary, but it doesn't tell you anything about the direction of payment. Of course, the reason it may be included, and probably is included, is that this provision doesn't just apply to litigation costs, it applies to non-litigation costs. So there is a limit to the cost that a designated person can claim to pay for his lawyer, and that is what Ofsted deems to be reasonable. And that makes perfect sense without impinging in any way, we say, on the argument that it allows the licensing of an adverse costs order
also,
to be paid.
You think about it in the context of licensing. It's if you like a break on anybody trying to do something improper by claiming an excessive amount of costs in order to transfer funds from the designated person's accounts.
Yes, and
so it obviously only grants a license if the fees are reasonable fees.
Yes.
So you'd say, well, if there's an order of the court, that's
the job is done.
If there's been an assessment of the cost by a cost judge.
Yes. It saves obviously the job.
It's a protective aspect to it, but it doesn't tell you anything about whether it's limited to the DP's costs.
That's right. And my lord, of course, you're right to say that there has been suggestion in the past that some unscrupulous lawyers in the European Union have been used effectively as conduits to move money around under transactions that are not really proper legal transactions. But this all enables obviously to control both the nature of the money being used, the type of transaction, and the quantum of it. There's nothing in that to cut against my submission. The final point my learned friend takes on this area is he says, and I mentioned this a moment ago, it only applies where the successful party hasn't yet paid its lawyers. And my lord, really, that would be rather odd. It would introduce into the regime this unwritten and completely illogical rule that an order for payment of adverse costs can be made as long as they haven't yet been passed already to the lawyer, but they can't once they have been. And there's no possible justification for that. There's certainly no sanctions related reason why that might be so, and I'll leave that as it is. I think it may be it may partly be based as an argument on the word enabling in Schedule 5, paragraph 3, because it said, well, you don't enable the payment if it comes after the event. But of course that misconstrues the word enable, because the enabling is the reference to the license, and therefore the person who gets the license is being enabled. And what's allowed is the designated person to pay the costs, and the enabling is not the enabling of the other side to pay their own lawyers, whether that's happened or not. That's the position there. On interest on costs, again, there's a small wrinkle here because, as you know, quite frequently this court will impose nowadays interest on costs routinely. There's no logical reason we submit why interest on costs, if payable, shouldn't be something capable of being licensed along with the costs themselves under this provision. They effectively represent, of course, the cost to the receiving party of having to pay their professional fees in the first place, time value of the money they've already incurred. Logically, and for sanctions purposes, there's no reason to think they would be treated differently as part, effectively, of the professional fees themselves, or to enable payment of the professional fees themselves, or certainly it should be treated, as we would say if it really needed to be, as an expense associated with the provision of legal services by the defendant's lawyers, by the receiving party's lawyers, to the receiving party, and recoverable under that heading. My lords, you will get the point, I hope, that both the governor of the Cayman Islands and the court of Grand Cayman share that view, because that's what they ordered and that's what they licensed. and that is what has now been paid. Security for cost, I'm not going to deal with at any length because it's common ground that that goes with adverse costs. I think your lordships might, though, benefit from just being aware, if you're not already, of where we are on security for costs in this case. The evidence is, and I don't need to show you, that the claimants have been ordered to put up £5.4 million worth of security for costs just for D1 to D4, those appellants before you today, and that applies in respect of the work done up to the exchange of reply factual witness statements, which I would submit is probably at least a year or two away, but maybe 18 months or so at the moment. The trial timetable has not been set in detail, you'll be aware, perhaps, my lords. The trial has been fixed for May 2025, but the intervening stages are yet to be specified. In any event, the court's decided that's the amount of security required up to the exchange of reply witness statements. It was paid into a bank account of Steptoe & Johnson, where it is held under the solicitor's undertaking to comply with the security for costs orders. And to boot now, of course, it is frozen under the sanctions regime, subject to obtaining a licence from Ofsted to use it. So it's not going anywhere, and the claimants, the appellants are protected to that extent. The position, I think I may have mentioned it, but maybe didn't show you, your lordships. Certainly I showed you the decision of Mr Justice Foxton in the ETB and Antipinski case, where he says that you should be able to get a licence for future unknown costs orders. And he partly based that decision on the Ofsted guidance that said they would grant a licence for security for costs in appropriate situations. And that guidance, in case I haven't shown it to you, we probably ought to show you. It's at tab 116 of the authorities bundle at page 5178. And this is the guidance that you'll remember I showed you an earlier version of with a picture of the City of London on the front.
Oh, yes.
And I told you this version didn't have the frequently asked question sections.
No.
But it does have 6.6.2, my lords, page 5178. And I can get two things out of this while I'm here, and I'll come on to the second. This is where Ofsted says that both court fees and payments into court for security for costs can be licensed under the reasonable legal fees licensing ground. However, Ofsted is of the view that a separate licensing ground needs to be identified to pay security for damages into court, depending on the specific circumstances of the case. And I'll come back to that when we deal briefly with the undertaking in a moment, because obviously that is, in a sense, security for damages, yeah, albeit in a slightly attenuated fashion or slightly specialist way under the freezing order rules. Now, the simple point there then, my lords, is that if Ofsted, as it rightly says, can clearly enable an order for security for costs to be made, Mr Justice Foxton agreed, clearly a simple order for adverse costs can be made and satisfied pursuant to a licence. None of this makes sense. If any of these licensing grounds permit payments, actual payments of adverse or favourable costs orders, of course,
well,
they
stand all full together.
And they imply the order itself can obviously be made, otherwise there wouldn't be a point in having them. I should have perhaps made that clear. Anyway, that I think is all I need to say on that, except perhaps it talks about security for payment into court here specifically. Can't make a difference if the court's ordered it to be paid into a blocked solicitor's account, in my submission. Wouldn't make any sense. It's a point of form rather than substance. But that's what's happened anyway in this case. Yeah. My clients would be content, obviously, to comply with whatever further order for security is made wherever it's ordered to be paid with a licence. Yeah. I think there is some agitation, incidentally, for further security to be put up. One of the oddities of this case is that includes one of the appellants before you, who has recently, within the last month or so, asked for further security to be put up. One of the appellants, yes, all of them, in fact, which is a rather curious thing to do if you think it's something that can't be licensed without, that it can't be done. Anyway, they clearly think the money is more important than the principle. Anyway.
Maybe that's a tactical move, I don't know.
it's inexplicable if they have any confidence in their argument in this court. Anyway, that's a forensic point. I'll move swiftly on. Cross undertakings, my lord. Cross undertakings. The current situation is that $2 million was ordered to be placed into another, or into Steptoe & Johnson's client account as fortification for the cross undertaking under the original freezing order, and then the undertakings that were offered in lieu of the freezing order. That amount was quantified at a contested hearing and decided by the judge to be the right level. During the, I think it was 2021 now, one of the defendants, one of the appellants before you certainly brought a heavy application to increase the level of fortification to around $20 million, I believe. That application was roundly rejected by Mr Justice Calver in the commercial court, and no further application has been made. So the position at the moment is that the commercial court has been satisfied that there is sufficient security in the Steptoe & Johnson account held pursuant to undertakings to fortify the cross undertaking to cover what the court has established at this point is the relevant risk of loss. And as I say, the cash is sitting there and is now doubly frozen, if you like, by the sanctions. Now, the first point to make there then is that there is no further risk of loss that the claimants have established, that the appellants have established that could require, that means they're undersecured in cash terms. But secondly, insofar as the question is whether the claimants, my clients, have paid the price for the undertaking, they have paid the price for the undertaking. They literally went into their pockets and put the money in a bank account. It's gone. So the price of the undertakings has been paid. If you put it in those sorts of forensic terms, then it doesn't help my learned friend because it's there. The only thing between his clients and the money, were there ever to, apart from at least 5 years of time, possibly more, is an office license. And I've just shown you that it's clearly office's view that a licensing ground might be identifiable, that it can be done, but not as a reasonable fees exception. And our point is that it would be rather remarkable if we're in this position, the court having found that there is a very good arguable case of fraud against these defendants, that they represent a risk of dissipation of their assets if they're not enjoined, that the price for the injunction has been paid and put into a bank account, but somehow the imposition of financial sanctions means that my clients aren't entitled to maintain the injunction, and they should be faced with the risk of all of the money that the defendants have being dissipated. But this goes back essentially to a question of the effective access to justice, because what is the object of a freezing order? It's to ensure that the claimant has effective access to justice by his claim not being rendered nugatory by unjustifiable dissipation post-issue. Now, that being the case, what sanctions-related purpose could possibly be fulfilled by the package of regulations authorised by Sandler, somehow preventing this court making an order for payment under the undertaking in several years' time, and for construing the licensing grounds as so restrictive that they wouldn't allow a sanctioned person to compensate a non-sanctioned person for the loss that they've caused. Now, the learned judge was quite right in my submission to say that the background to that, the origins of the rules and the purposes of the sanctions, means that if it is necessary to do so, one would be able to get a licence under the exceptional reasons heading, which is paragraph 5, I beg your pardon, of Schedule 5, to enable an extraordinary expense. It is fair to say that payments out under cross undertakings are pretty extraordinary in the sense that they're rare and unusual, and there's no easy way to predict whether they will ever happen. They do sometimes happen, and it is part of the process. But if the alternative, my lords, is to have the consequences I've just outlined, then it would be imperative and necessary, and the court, I would say, would be bound to construe that as covering the relevant payment, because otherwise the principle, the effects on a claimant's access to justice would be as I've said. I should say, of course, that it all goes to the same point I made before, which is that it's not rational to imagine that the executive would consider it inappropriate for a designated person to have their assets diminished in order, if there were a licensing ground that is capable of covering it, in order to compensate someone who was a non-designated person. It would be really quite extraordinary in itself if the executive had chosen to impose the punishment or sanction, if you like, on the designated person, and then prevented an innocent person that has been found to have been damaged by a court from actually being compensated. So we say that that is why there will be, if the sanctions regime continues in the same form at the time that this would ever become relevant, which my Lord the Chancellor suggested is indeed many, many years away, if ever, why there will be a way in which the payment out is likely to be payable, should it be ordered. That's why there is no realistic basis on which to discharge the undertakings at this point. If we're right on that, then...
I mean, it's an asset freeze that doesn't involve, as part of the sanctions regime, the concept that at some stage in the future the money will be expropriated.
That's correct.
Unlike a freezing injunction in one sense, because if you freeze the assets on the basis that at some stage in the future you will enforce a judgment against them.
Yeah.
So that's why when courts police freezing injunctions, they are careful about the diminution of the assets which are otherwise the subject of the freezing order.
Yes.
But here, that sort of concern doesn't apply at all.
Doesn't apply, but even if it were to, my Lord, this would be a diminution of the assets in favour of the person who's been harmed.
So the person who's going to be
putatively been harmed.
this hypothesis getting the money at the end of the day.
Yes. And we do say that the appellant submissions more generally just lose sight of these obvious, rather important, bigger picture points in their attempt to parse the language to avoid having to face the trial of the fraud claim against them. So first of all, I would say there is we invite your lordships to decide that there would be a ground for licensing, even if the sanctions were to continue in their same form, and my clients would be subject to them in the same way, in however many years' time it would be relevant. Secondly, we invite you to say, well, it's simply too soon to say what on earth the position might be, and that given the circumstances I've outlined, it would be wrong to discharge the order now. But in any event, if it came down to it, and one had to make a decision now, and I heard my Lord Justice Popplewell suggest this was a matter of discretion in a sense for a first instance judge to weigh all the facts, but that would be a fallback position from our side, because we would certainly submit that this court couldn't discharge the undertakings at this stage, because you don't have the evidence, for example, of the strength or merits of the claims. And I'd want to be able to tell the court about that. And you don't have the evidence about what might or might not happen in the future, or what people can say about how long it will take, or those sorts of things. So I do say you can't discharge it, but I would invite you to say that given the findings you are invited by my clients to make on the law, there are no grounds to discharge it, in fact. Failing that, if it is a discretionary matter and your lordships were to want to decide it, all I would say is that there is jurisdiction in the court, even where no money is put up for security, to make a freezing order in exceptional circumstances. One sees that occasionally where the fraud itself has given rise to the impecuniosity of the claimant. But that needn't be the limit of it. We're in a peculiar position where my learned friends can't say that we didn't pay the price. They simply say that they can't, the government has prevented them from accessing the price. And it is slightly different in my submission. But it would be surprising if a claimant who was genuinely impecunious but had a very strong case of fraud and a very strong case of dissipation could never get a freezing order in any circumstances. I'm not going to go into the dicta in Pugachev and quite how far it goes and whether it is limited to receivers or liquidators or office holders and things like that. But I don't apprehend that this court will want to descend into the discretionary elements of the exercise. But I do invite you to rule out, by making the findings I've invited on the law, any realistic prospect of us having to face another argument about this later. My Lord, can I then deal with a couple of conclusory aspects and a couple of mopping up points? That's all I wanted to say on the licensing regime, unless I could help you further. A couple of points, I suppose, of perspective, and inviting you again to stand back and look at the bigger picture in terms of what my learned friends are inviting the court to do with the sanctions rules. I'm going to go back first to take a personal injury claim example, just as an accessible way of testing some of the principles. I do invite the court to imagine a person in London who is deliberately attacked in the street. He sues, or he wants to sue, his attacker for his personal injuries and his financial losses, let's say lost earnings, ripped suit, whatever it happens to be. It would be a mixture of personal harm and financial losses. Now, my learned friend's case is that if the victim was not a designated person at the time of the attack, but was designated shortly afterwards, or any time afterwards, under what I repeat are financial sanctions regimes, then the victim of the attack is totally unable to come to court to proceed with his claim. He stayed immediately, and he wouldn't be able to get any redress for the wrong, even in the form, it is said, of a public declaration by the state of the wrongdoing and the violation of his rights. You might think that is surprising if that's the result of a financial sanctions regime, but that is my learned friend's case, and it has to be, and it is equally applicable to a claim brought for any other type of tortious harm or any other claim.
But even on your case, the position isn't so different. Leave aside what you might achieve in another country, whether or not the court can adjudicate on the claim, you can't have the money.
Well, my lord, I would strongly suggest that the adjudication on the claim and the entry of the judgment is the point. I accept that commercial parties want the money. There's no question we're not here for the glory, but the principle for the court, I really do urge you most strongly to bear in mind, is that people are entitled in this country to have the court declare their rights and obligations and make the order.
But the person who's been attacked in the street doesn't just want an adjudication, he wants the money, and he can't have it.
Well, my learned friend's case is he can't have the money, and therefore he can't have the adjudication, and therefore he can't have his day in court. The minimum that this court can do for a victim in that position is to enter judgment in his favour, hold up the defendant to the appropriate opprobrium, and let the executive decide what can be done with the order. Anything less than that is an interference of the plainest kind in the court's fundamental constitutional role, which is entirely unjustified by any words in Samler. And that is the bottom of my submission. The problem is that, of course, the oddity, I suppose, in my learned friend's case is that in that example, the attacker, if he were genuinely repentant and contrite, would be able to admit liability and pay the money into a frozen bank account and do his best to offer redress, compensation and admission. But with a deliberate and recalcitrant wrongdoer, Mr. Rabinowitz is saying that the court is unable to coerce them to appear and explain themselves and face the music. That would be really, in my submission, rather remarkable for a country that's operating under a rule of law, whatever one might say about Russia. And I mentioned it yesterday, but obviously the problems slightly multiply in terms of how the Act is supposed to work on my learned friend's case if you're in the realms of a post-designation attack on a designated person, because it appears to be the case that the attacker is also committing a financial sanctions breach by making available a cause of action. Now, that suggests in my submission that causes of action can't all be economic resources of the relevant sort, because that would be a remarkable crime to be committing when you stab someone in the street. But I leave that hanging. It doesn't matter to my case particularly. But one of the things that possibly does matter more to civil claimants is that if my learned friend is right on his reading of Regulation 11 in particular, once the designated person has issued a claim before or after designation, he can't even admit that some of it's wrong or concede it, because that would change the value of his claim and be a use or a dealing in assets within Regulation 11. And again, one has to question how that could possibly be a rational system of law. The other way I'd like to invite the court to test the bigger picture points, if you like, is to just consider the position of a designated person who is a defendant. Because obviously we're a claimant at the moment, and that's how it's happened to be. But whether you're a claimant or a defendant in a civil claim obviously can be a matter of happenstance to some extent. And I say that because it's happened in this case. You know there was a parallel arbitration between related parties and my clients in the LCIA. In fact, the companies who were controlled or owned and controlled by the defendants in this case got in first and started an arbitration for a declaration of non-liability before my clients commenced an arbitration the other way. And so in that case, one had the designated person, as they became, a defendant counterclaiming for the same relief as we claim here effectively, but as a counterclaim as a defendant. So the first thing is, this is not a hypothetical case, it's a realistic prospect, and it all rather depends which party gets in there first. If you look at it through that lens, then you imagine that a party with an arguable claim, a non-designated party, a perfectly innocent party, comes along and has a claim against a designated person in the High Court, and there are no questions of sanctions involved in the substantive dispute, so we're not in the realms of Section 44, it's just a pure civil claim by one person against the other. Now, that claim might be well-founded, might be very well-founded, but the designated person resists it vigorously and hires clever lawyers to think of every possible argument and takes it to every possible appeal, etc., etc. Yeah. My learned friend's case is that whilst the claimant could get judgment against the designated person, I assume, I'm not sure actually, maybe he'll tell you, but I understand his case to be that he couldn't get a costs order. So no matter how much cost the designated person has caused in vexatiously defending a good claim, there is no basis on which the court could ever order a costs order against him. That would be rather odd, and there can't be any sanctions-related purpose to that conclusion, I would suggest. But you imagine the opposite situation, where the claim brought against the designated person is hopeless, and it's purely done and rightly purely done for tactical reasons. It's rightly resisted by the designated person, who has to spend millions on his lawyers after getting a license to pay them, and he wins hands down in the claim. Again, my learned friend's position is that there is no possibility of the court making a costs order in his favour. And that means that designated people are at the mercy of unscrupulous and vexatious litigants, because they can be put to whatever cost is necessary with no consequences at all on the innocent, so-called innocent party. That is also something we suggest that the regime can't possibly tolerate. Then the final example I'd just like to give you is one where you have counterclaims. And we've made this point in the skeleton, and to some extent it's been responded to by my learned friend. But if a claimant who's non-designated brings a meritorious, prima facie meritorious claim against a designated person in the court, but the designated person has an equally meritorious claim against them, which he can set off in law or in equity as a defence or counterclaim, how is the court to proceed? Of course, if it's a legal set-off, it would amount to an actual defence in law, an abatement or something of that nature perhaps, which would diminish the legal liability under the claim as a matter of law. If it's an equitable set-off, the court would be bound to give effect to it if it was so closely connected that it wouldn't be just not to. Probably not summarise that very well, but you know what I mean.
Yeah.
And no court of equity could enter judgment without doing so. But what is to happen. If that's the case, my learned friend's case, if a judgment again in favour of a designated person or giving credit to a designated person for a claim is prohibited by the regulations, then the court can't enter judgment in favour of an innocent party, if there's a legal set-off at all, or the designated person would be entitled as a matter of equity to a stay of the claim against him. And the result on my learned friend's case is that these sanctions against designated persons actually prevent the court entering judgment in favour of non-designated persons. And in fairness to my learned friend, he essentially accepts that in his skeleton, paragraph 69, because he says, well, of course, there might have to be a stay, at the very least, if there is an equitable set-off raised by the designated person, because otherwise the court would be doing what he says you can't do under regulations 12 and 13 or 11. That is one good illustration in my submission why, however you decide to approach it, interpretation of the words, reading down, court is not a person, not binding the court, any of those methods will get you to the right answer, which is that in that situation, the court can enter a judgment in favour of the innocent person for the right amount. None of that is possible under my learned friend's approach, and that's the approach. Therefore, our approach is obviously the correct one in that submission.
In other words, however you get this regime is not intended to encompass the court exercising its judicial process.
Exactly, just as the Court of Appeal said in R&R. Right, two mopping up points then, my Lord, finally, before I hand over to Mr. Davies for controlled. I'm sorry, three. Firstly, I better mention the Duport principle because it's one of my learned friend's favourite points. It's not a good point, I'm afraid, in my submission. It plainly doesn't apply here. We're arguing, all our arguments are about the interpretation of the regulations and their meaning, not the application of something that is of plain meaning, even taken in its context and purpose. I might give you, Lordships, an example of what I mean. I think my learned friend would let's take an example. Imagine a statute said, or a regulation said, that a person must not seek to coerce another to act or not act by threatening to take away their liberty unless they do so. Something like that. And it's clearly geared towards stopping people threatening to lock them in their garage unless they pay up some money or whatever. Now, on my learned friend's approach, asking whether that took away the court's right to commit contemnors for breaches of court's orders would be a question of application, not interpretation, because that's what the Duport principle means. And so you'd be in a situation where each of the words is clear, and you'd be trying to parse it to work out whether it applied to the court's jurisdiction, to take away the court's jurisdiction to lock people up. And that's why his distinction between application and interpretation is wrong in this case. Now, of course, there is a way of getting through that on an interpretation basis quite easily, because you simply say that the person in that case can't have been intended to be the court. But this is not a Duport principle or problem. That's, I'm afraid, a fancy label that's been attached to an argument that tries to avoid the consequences of a proper interpretive process. So that's that. Second point I want to mop up is workarounds. And I, again, use that cautiously because I think it rather understates the constitutional rights some of them involve and entail. But I'm using it because we know what it means. Now, my learned friend said for the first time, I think, orally on Tuesday, this was never in his argument below, or in his grounds of appeal, or in his skeleton. But he now says that Regulation 19 on circumvention would prevent the court taking the approaches he describes as workarounds, including declaratory judgments, entering judgment on liability with quantum to be assessed and so forth. I don't need to deal with this for very long, my lord, because the whole principle of circumvention is clearly not engaged in a process where if it's decided that one object, namely the entry of a judgment, money judgment, is prohibited, an entirely different object is aimed at and achieved by an entirely different method that is not prohibited. That's not circumvention, that's taking a different legal course to a different objective, albeit with the same overriding purpose of access to the court, but it doesn't possibly engage the ideas of circumvention. And I commend to your lordships, but I don't need to take you to the analysis of Lord Justice Briggs in R&R on that.
I was going to say, I think we looked at that yesterday in Lord Justice Briggs's judgment.
We did. It's authorities tab 83, 4366, paragraphs 57 around there, but you don't need to go back to it. That was an even stronger case, if you like, in my learned friend's favour, because in there the objective was the same. It was to get money from the husband to the wife, but the court said it was not a circumvention to pay it in Russia rather than in England, even though one didn't require a licence and one did. We're not even in that realm, because we're not saying, well, we can achieve the entry of judgment for a money sum by some other route. We're simply saying, well, we'll aim at a different target that is as far down the road of access to justice as we can get before you hit this supposed barrier of actually making a money order. There's no circumvention involved in that at all, possibly, in my submission, and that therefore possibly explains why it was never made as a point before. And then finally, I just wanted to make one comment on the Mollendorf decision, which my learned friend referred to. It's at tab 58, page 3482. You remember it's the land registry decision in the German courts, or from the German courts to the European court. That, my lords, has nothing to do with this case. It was a case where there was a transaction, a commercial transaction between two sets of people to sell land, and once I think the buyers ended up being designated under the European sanctions. And so the question was whether the seller, the contract of sale, if you like, could be perfected so that the buyers ended up with title and free access to and ability to sell the land, despite the fact that they'd been designated in the meantime. So it was a commercial transaction case. And the question wasn't whether the land registry was prohibited from registering the transfer. The question was whether the seller could require the land registry to register the transfer. It's a slightly subtle point, but it's important, because what happened in that case was the seller brought an action, say, effectively, I suppose, a sort of judicial review against the land registry, saying you must complete this deal. And in fact, it was the seller's notary who sued. And the land registry said, well, now they've been designated. If we enter judgment, you're going to be giving this person a final title to the land you've sold them, and we don't want to do that. The question for the court was, is it a making available to allow the perfection of a commercial transaction in which land would undoubtedly, in that case, have thereby been made available to the buyer? And you'll see that therefore is a question of whether the seller was making it available and whether the land registry was right or wrong to refuse to assist. But what it doesn't do in any event is engage any of the principles of effective access to the court. That's why even if it's a question of somehow enjoining a state body from doing something in a commercial transaction, it's totally unrelated in my submission to the realms we're in, which is the fundamental right to access the court for a determination of rights. That's all I want to say about Mollendorf, my lord. There's a final point I should pick up, Russian VAT, which I know is slightly technical and narrow, but there is fortunately some answer for your lordship. The first is that if you look at the skeleton, please, of the first and fourth defendants in the court below, supplementary appeal bundle tab 15, page 310, you'll see paragraph 9.1, where the first and fourth defendant, who are then separately represented, which is why it's like that, refer to the fact that the parties have agreed the factual and legal position as regards Russian VAT, which came as something of a surprise to me. But they'd agreed it in terms of a document which was then referenced, which isn't in the bundles, but which I can hand up if your lordships would like to see it. And it represents an agreed explanation of how Russian VAT came to apply to English lawyers' fees. If your lordship can bear to
in due course.
read it, I'll hand it up.
Don't take time.
Perhaps we'll tell you where in the supplementary bundle of authorities it's gone, and we'll put it at the back. Unless I can assist your lordships further on my aspects of the case, I'm proposing to hand to Mr. Davies now to deal with the control issue.
Thank you very much, Mr. Can I just ask you one thing?
and it concerns really the scope of the principle of access to justice for the purposes of the principle of legality, and therefore where we are in what have been dubbed workarounds, but I think maybe one more important than that, and whether you go only as far as a declaration of liability, or you go as far as a judgment debt, or you can go, though you don't need to for this case, even further in what the court can do without reaching sanctions. Now, I quite understand that if one's looking at it from the point of view of continuity of the EU regulation, you say, well, look at Article 7, which allowed compliance with a judgment provided it went into a frozen account.
Yes.
That must mean that what is contemplated as carved out is the court going at least as far as giving a money judgment. I understand that from your continuity argument.
Yes.
But looked at through the perspective of your principle of legality argument, what is the access to justice principle? Sometimes we see reference to vindication of rights, which one would think is satisfied simply by a declaration in relation to liability. Sometimes we see references to effective remedy,
Yes.
which one would think would go all the way through, not just to giving a money judgment,
Yes.
but to making the proceeds available.
Yes.
And when I had this discussion earlier, you were suggesting that there was nothing the court might do which wouldn't also involve a further breach of sanctions, but one can think of examples. I have thought of examples where that isn't necessarily the case. There's some money in a safe, and the court orders someone to hand over the key or the password, and allows direct access. It may be that there are better examples, but the element of going beyond a declaration of liability and giving a money judgment, which is an order to pay something,
Yes.
looks a bit more on the enforcement side of the line. And I'm not quite sure whether your case is that the principle of legality operates to carve out from the operation of the sanctions anything the court does, including enforcement in the extreme sense that I've given of enabling someone to get their hands on the money in the safe. And if not, where is the line?
Well, I think my primary submission would be that it enables the court to do anything which the court can do within the normal course of its functions, along the lines that suggested by the Court of Appeal in R&R. The principle of legality would require the sanctions regime to be specific about what the court was not allowed to do.
Sorry to interrupt you. But therefore, for the court to do something which enables the designated person to get their hands on the money without it going into a frozen account, because again that would be contrary to the continuity argument.
Well, I'm not sure for my own part, my lord, in my submission that I can think of an example where someone, if the court ordered someone to give the keys to a safe, for example, with a load of cash, whether the person who was then going to hand over the keys to the safe wasn't being in breach of sanctions, because they'd be making available the contents of the safe.
No, the court would be ordering them to do so.
Yes, but in my submission, the court wouldn't order something which would entail the party to whom this order is directed to commit an offence. And so my submission is that the controlling factor, if you like, on whether the designated person gets their hands on the money comes at a point beyond which the court can do anything it is able to do and would normally do, but it would never order anything to be done that would be unlawful under the law of the country in question, certainly not in this country. And that limits any practical problem from what I perceive your lordship to be saying is the risk of a court order effectively giving them more than they get under even the EU rules, which is the right to access frozen, the right to money into a frozen account.
How does that relate just to an order for the payment of money? Because the payment of money would be contrary to sanctions in this country.
It would in this country, but it might not be any. It might be achievable outside the scope of sanctions.
Does I understand your point? To come to this, let's just focus on the money judgment for the moment. If at the end of the day, assuming sanctions are still in force, the commercial court grants you a money judgment for whatever it is, $50 million or whatever. The court can do that. What can't happen, at least as matters current stand, is that the defendants actually pay you that in this jurisdiction.
Yes, that's right.
But it doesn't follow from that, you would say, that you could take that English judgment and go to another jurisdiction and seek to enforce it in another jurisdiction if they didn't have the same sanctions regime.
Perhaps that, yes, it doesn't follow that it couldn't be done. I don't know whether it could or couldn't. Of course, it depends where you go and whatever its value would be. But this is talking about not ignoring the workarounds, of course. But yeah, that's right. And my lord, one can't, of course, discount the possibility that a defendant found to be ordered to pay 50 million could in fact pay 50 million pounds from a fund outside. I mean, they not every defendant will be a UK national. As I say, it may or may not apply to these individual
That might
defendants.
be said to be what happened in R&R, mightn't it?
Well, that's right, in the opposite direction, because the court said, well, neither party doing anything in Russia is a problem, so the court can make an order that can be fulfilled and finished, if you like, in Russia.
Yeah.
But
So my lord's example of the safe, what if the safe is in another country?
then, yeah, well, it depends who the person is who's being ordered to open the safe. But if they're not a UK person or within the jurisdiction, in theory, they could open the safe. But in a way, that's only to say that the sanctions don't purport to freeze the contents of the safe. Mm. And that's an important. And when you read R&R, as I urge you to do again, that's the kind of point, in a way, that Mr. Lord Justice Briggs is getting at, and later on. The sanctions don't try to impose any restriction on any asset or any dealing with an asset outside the realms of the jurisdictional limit. So orders for payment don't have no purpose if they could be fulfilled by a non-sanctioned route. And there may well be such routes in many cases, is all I can say at this point. I suppose you might go so far as to say that if it could be shown that there was no possible legal way to satisfy it, there wouldn't be any point making it, but I'm not sure that's right. But I do say, I think, to answer my Lord Justice Popplewell's question more directly, that the right of access to the court is for determination of your claim. And that must include, if you've got a claim for damages, for an order that the other side compensate you for that harm. But as I say, I'll fall back on all of the other options if that's not what this court agrees with.
Thank you.
My Lords, I'm going to hand over. I don't know whether that, since there'll be a little bit of a logistical shuffle, we should have a break, or whether you'd like to press on.
It would be sensible, wouldn't it, to break now?
So 5 minutes now, and then we'll
We're
rearrange
breaking into
ourselves.
Mr. Davis in 10 minutes, so we say 5 minutes now.
You may maybe. Stay seated.
If you are, then I think we're going to have Tom to take a short lunch. Yes.
We've got till 2:15, haven't we?
On there, yeah. We've
Without
got some time
sitting
after
late.
lunch. We definitely need 2 hours, possibly. I think, yeah.
Still standing, my lord. A bit of an esprit d'escalier, I think. I had a further thought I might pass on to your lordships in light of Lord Justice Popplewell's question before I sit down. And that was just this, that of course some of the problems that we encountered in that discussion, or potential problems, might be alleviated by the court making an order that was express, entering judgment, and then providing that nothing in the order, entering judgment for money sum to be paid, but providing expressly that nothing in the order required or permitted any person subject to any relevant sanctions regime to do an act that was in contravention of it, or to fail to do so, I suppose.
Yeah.
Because that would guarantee that the court order only required people to do things which were lawful and didn't permit them to do those things which were not.
Yeah. Yes, Mr. Davis.
My Lords, I'm going to make three introductory points before turning to the language of Regulations 7.2 and 7.4. And that these are points really to put the debate in the context of the regulation as a whole. First, I want to introduce in a little more detail the structure of NBT, CBR, and the role of Miss Nebulina. But that won't involve going into any controversial evidence. I'll focus only on uncontroversial points. Second, I want to look at how the asset freezing sanctions fit in with other sanctions in the regulation that do apply to the CBR and the government of Russia on their face, and indeed the other sanctions in the regulation that do apply expressly to all Russian companies, because there are sanctions that do apply to all Russian companies. And thirdly, I want to look at how the question of control fits in with the asset freezing sanctions themselves, before then turning to the text of Regulation 7. Now that's a little bit of a run-up, but in my submission it's necessary to put regulation in context and put the asset freezing sanctions in the context of other sanctions in the regulations. Now, in terms of the entities involved, that's the first point. I'm just going to make a couple of points by reference to the defendant's own evidence at first instance, so you can see some of the structure involved. NBT is formerly a retail bank, but is no longer operating that business. It collapsed and was essentially bailed out. It's now essentially a subsidiary of the Russian Central Bank. And you can see just briefly how that works by reference to the defendant's own evidence, their Russian law evidence, which you find in the supplemental appeal bundle, tab 3 at page 42. Because at first instance they produced a report from a Russian lawyer, someone speaking to Russian law. I'm just going to show you a couple of passages from that. If you see page 42, this is, you have para 55. This evidence describes how NBT is owned as a basically almost wholly owned indirect subsidiary of the Russian Central Bank, owned through an intermediary entity called the Banking Sector Consolidation Fund Asset Management Company. That's paragraph 55A. And that's a so-called trust arrangement under Russian law. But there's no doubt that NBT is owned and controlled by the Russian Central Bank, whether you call that an indirect or a direct holding of the shares. It's owned and controlled by the Russian Central Bank. And equally, there's no doubt that the Russian Central Bank is not named as a designated person on the public list for the purposes of the asset freeze. Now, in terms of the central bank itself, its role is obvious as a central bank. It also acts as a regulator in the Russian system. But there was something also in this report which provides a helpful description of how it fits in at page 52. And this is the defendant's own evidence.
Page 52.
Page 52, bundle page 52.
Thank you.
And you've just got a reference here in these three paragraphs at 88 to 90 as to the relevant legal provisions The first one is a reference to Russian Civil Code, the RCC. The second is the Russian Constitution, which describes in general. So then the point I'm really interested in is that the CBR law, which is at para 90, the CBR shall be a legal entity based in Moscow. The authorised capital and other property of the Bank of Russia shall be in federal ownership. That's what you'd expect, and that confirms the position. But if you just look briefly over the page, it has its own legal personality. Now, it follows that if anyone could be said to stand in the position of owner or equivalent of the Russian central bank, it's the Russian state itself, and it's equally clear that the Russian state is not listed as a designated person for the purpose of the asset freeze, nor is the Russian government or any equivalent term. The state and the government are not listed as designated persons. Now, and in that sense, it's quite different from the Iranian sanctions. Well, Lord Justice Newey may remember that Modsaf, that was the Iranian Ministry of Defence, which was itself listed. There's no equivalent of that here. The state and the government and the Ministry of Defence are not listed. Now, just to complete the picture, we can see the designation of Banca Criti actually in the authorities bundle, because the authorities includes the list of designated persons. So that's at tab 18, page 1499. I've taken these references from the authorities, so tab 18, page 1499. And Bank Criti is right at the top of page 1499. And what's notable about that is they obviously give the reasons for designating, and they say that Bank Criti Financial Corporation is the only bank of systematic importance that is owned by the Central Bank of Russia. That's the reason the executive was given for designating it. Of course, MBT itself is not a designated person. Then just to complete the picture,
It might be thought to be slightly odd, if that's the rationale, why isn't NBT? I mean, you can't answer that question.
No. It's a political question.
It's certainly, looking at the reasoning, it goes on and saying supporting and obtaining a benefit from the government of Russia, owned by the Central Bank of Russia.
Yes. But there was actually evidence.
Government of Russia.
Yes. There was actually evidence at first instance relating to discussions that had been had in Parliament and questions asked about whether NBT should be designated. But the fact is it hasn't been, and that's ultimately a political decision. But it's not an oversight because it's actually been raised.
Because I say it's carrying on business of economic significance to the government.
Yes.
As you say, it might be a distinction.
Yes. But what is notable is that the designation itself says it's the only bank of systematic importance owned by the CBR. So for whatever reason, that's the decision. Now, to complete the picture, Miss Nabulina's designation is at 1399. She's person 821 on the list at page 1399, and she is designated on the basis she's obtaining a benefit from or supporting the government of Russia through working for the government of Russia as governor of the Central Bank of the Russian Federation. And finally, Vladimir Putin is designated at page 1428. Although the reasons for that are not difficult to discern, but if you want to look at it, it's at page 1428. So that introduces the cast of characters. The second point is other sanctions dealing with the CBR and the government of Russia. And I'm talking about other sanctions that are in the same regulation. This was a point the judge summarised in her judgment at paras 211 to 215 at core page 186. It's helpfully summarised there, and it's not controversial in itself, the summary of the other sanctions.
Sorry, page.
It's page 186, the core bundle. I want to just take a little bit of detail on this, but not too much. So judgment paras 211 to 215. There are various other sanctions outside the context of the asset freeze that apply specifically to the government of Russia as defined, and also that apply specifically to the CBR, the central bank. Now, the first set of sanctions like that is what the judge describes at 211 as the banking or capital markets sanctions. So these are regulations 16 and 17. And the point is, the first point is that these now apply to the government of Russia. You can see these at page 920 of the authorities bundle. So it's regulations 16 and 17. Sorry to jump around, but it's regulation page 920 of the authorities bundle. Regulations 16 and 17. So regulation 16 is dealing with transferable securities or money market instruments, and various dealings are prohibited. And 16.4f includes, on the next page, transferable security or money market instrument falls within this paragraph. It is issued on or after the 1st of March 2022 by or on behalf of the government of Russia. So there's a specific intention to subject the government of Russia to that sanction. Then the next regulation, 17, let's make a couple of points on this. This is a prohibition on granting loans to particular persons. And it's steadily been widened by amendments over time. It was quite narrow in its original form, but you'll see there's a lot of amending being done. And various different categories of loans are prohibited. And over the page, the category 4 loan, if you see that, a category 4 loan means a loan or credit made or granted to the government of Russia, which is first made or granted at any time on or after 1st of March 2020. So that's prohibited. Now, government of Russia is itself a defined term at in the regulation, as the judge noted. The definition is at page 909 of this, at regulation 6.7. So the draftsman has defined what they mean by government of Russia. It includes, this is page 909, it includes the presidency of the Russian Federation as they describe it, various other public bodies, and D, any ministry of the Russian Federation, so that comes in there, and F, the central bank of the Russian Federation. So they've expressly prohibited granting a loan to anything that falls within that definition. Now, the next point, if you go back to regulation 17 at page 923, another type of loan that's prohibited is a category 3 loan. This This is at the top of 923. And a category 3 loan means a loan or credit with a maturity exceeding 30 days, made or granted to a person other than an individual, which is one connected with Russia. Now that's quite an important point, because connected with Russia, I'm not going to go through every single one, but is a phrase used over 100 times, I think, in the regulation, or person connected with Russia. It's quite an important concept in the regulation. It is defined at Regulation 19A2 on page 929. Page 929, in the middle is 19A2, where it says, for the purposes of this part, a person is to be regarded as connected with Russia if the person who is, and it's an individual ordinarily resident, an individual located in Russia, a person other than an individual which is incorporated or constituted under the law of Russia, or a person other than an individual which is domiciled in Russia. So a person connected with Russia definitely does include every Russian company, essentially. And Regulation 17 is an example of a sanction that is intended to apply inter alia to every Russian company. You can't grant any loan over 30 days to any Russian company. As I say, this expression, person connected with Russia, is then used time and time again in the regulations. And in particular, all of the trade sanctions apply to any person connected with Russia, such that you can't sell particular types of goods to any Russian company at all. And just an example of that is at page 941. So this is just one of many examples that could be given. At page 941, you have a provision about transferring restricted technology. And you can't transfer restricted technology to a person connected with Russia. So that's any Russian company. It doesn't matter if they're associated with the regime or the war or anything like that. You just simply can't transfer to any Russian company. Now, obviously it's going to be part of my, well, before I come to that, just the CBR, just to complete the picture, because there's a separate sanction that applies only to the CBR, or to the CBR and other related entities, and that's 18A at 926. So 18A is a specific sanction against providing financial services relating to foreign exchange reserve and asset management. So you're not allowed to provide those types of services to people including at 18A2A, the Central Bank of the Russian Federation. So as the judge noted, and as we've just seen, that the government of Russia, presidency of the Russian Federation and Russian Central Bank are all terms expressly used in the regulations, but none are listed for the purposes of the asset freeze. Now, obviously I'll come back to the significance of that in the context of the language. In terms of how control fits in to the asset freezing, the sanctions.
I'm not sorry, Mr. Davis, just looking at that 18A. NBT would in fact be covered by subparagraph 2D.
Yes, absolutely.
So it is in fact subject to sanctions, albeit not the ones we've been looking at.
Yes, a person couldn't provide those types of services to
NBT.
NBT. That's absolutely correct. Because it clearly is owned and controlled by the central bank. So the final introductory point is really to see how it all fits in the concept of control fits in with the asset freezing sanctions themselves, because it's quite important to note that if you are a controlled person, that does not make you a designated person. There are obviously important consequences for being a controlled person, but the designated people are the people who are specifically on the publicly available list, and one can access that on the government website and so on. Being a controlled person, it doesn't actually make you a designated person. It has other consequences. And in terms of the asset freeze, you see that at 3 places. The first of those is at Regulation 11.7 on page 918. Obviously, Regulation 11, we're going back to the no dealing regulation. And Regulation 11.7 says that, you see that there, funds or economic resources is to be treated as owned, held or controlled by a designated person if they are owned, held or controlled by a person who is owned or controlled directly or indirectly within the meaning of Regulation 7 by the designated person. That's the first way it comes in. The second way is Regulation 12.4, that's making funds available to a designated person. And obviously the prohibition in 12.1 is do not make funds available directly or indirectly to a designated person. And the control issue comes in at 4, where it says the reference in 1 to making funds available indirectly to a designated person includes in particular a reference to making them available to a person who is owned or controlled directly or indirectly within the meaning of Regulation 7 by the designated person. And the same structure appears in Regulation 14, where the prohibition on making economic resources available to a designated person has the same kind of language. So it's in those regulations, it's making funds or economic resources available indirectly to the designated person by making them available to a controlled person. So in context of those provisions, one is actually asking questions like this. If you make funds available to NBT, does that make funds available indirectly to the CBR? Yes, it does. It clearly does, because we've seen that the CBR is the owner and controller of NBT. But of course the CBR is not itself a designated entity for the purpose of the asset freeze. The logic of the defendant's case construction is that making funds available to NBT indirectly makes those funds available to Vladimir Putin or Miss Nabulina. They have to say that. Those are the only 2 relevant designated persons relied on. So if the fund being made available is a judgment debt, for example, it would be said, well, entering judgment in favour of NBT constitutes indirectly making that judgment debt available to Vladimir Putin and or Miss Nabulina. So those are the introductory points. Turning now to Regulation 7 itself, which is at page 912. In my submission, it makes sense to, as the judge did, construe and understand 7.2 first, the first condition, before then turning to what does the second condition mean in view of what I've determined about the nature and scope of the first condition. That was the approach of the judge. It's a logical approach of my submission. So I'm going to focus on the first condition first, that's 7.2. I just want to make some points first of all, just by reference to the text of the regulation itself as we see there before then turning to Schedule 1, which is an aid to interpretation or helps the interpretation. Now we do rely on the fact very strongly that 7.2 has got 3 alternative conditions or elements, and each of them uses the word holds. So the person has to either hold the majority of the shares, hold directly or indirectly more than 50% of the voting rights, and we'll see when we come to Schedule 1, that means the shareholder voting rights or equivalent, or hold the right directly or indirectly to appoint the majority of the board of directors. So those are the three elements: holding shares, shareholder voting rights or rights of appointment. And what unifies those three things is that they are the rights of shareholders, of the rights of the owners, the economic owners of a company. In other words, 7.2 on its face is directed at shareholder level and not at the level of management of the company. Now, take the example of a state official occupying a particular office. The state itself may hold various rights in relation to state-owned companies or other entities that that person is involved in exercising. For example, the Minister of Energy, and this is just hypothetical, but the Minister of Energy might be responsible for taking important decisions in relation to a state-owned energy company. So it's the state who has the rights to appoint the directors to the board of that energy company and to vote the shares, and it's the state who hold the shares. They're not a personal asset of the individual minister, and they don't belong to the minister. He doesn't hold them in any meaningful sense. The minister could die, resign, or lose office in some other way, but that wouldn't change in any way the fact that the rights and the shares continue to be held by the state, by the Russian state. In other words, in that simple example, what the minister does is he exercises the state's rights on its behalf as an office holder. He doesn't hold the rights himself, in my submission, as a matter of ordinary language looking at this. And you do get into a total confusion in that example if you say that the individual minister holds the shares in a state-owned company. And that's not a natural use of language at all.
I mean, just to be clear, on your hypothesis, which must be the normal situation, it is not the individual minister who does hold the shares.
Yes, it's a true state-owned company. So the rights belong to the Russian Federation. The shares so belong to the Russian Federation. And
I mean, you'd get a slightly different question if under the particular country's regime, the shares were vested in the Minister of Energy for the time being.
yes, that would be different, but that's not the situation here. Another example of the same principle, we would say, is a director. And by that I mean a director. Let's postulate an example of a director of a company who has no ownership interest in that company. He's just a director on the board. Now, a director, a non-owner director, does not hold any of the shares. He doesn't hold the shareholder voting rights, and he doesn't hold the right to appoint the board. So just as a matter of ordinary language, and this is obviously where we part company with the judge to some extent, we would say it's just a matter of ordinary language. It's clear that a non-owner director or a CEO would not fall within the ordinary language of 7.2, focusing on 7.2 for the moment, because 7.2 is focused on shareholder level. Now, there's quite an interesting point in relation to that.
I think this is an irrelevant gloss, but just suppose you had a parent-subsidiary structure where the right to appoint directors of the subsidiary was vested in the chairman of the parent.
But that wouldn't be a personal. If he stopped being chairman, he would no longer have that right. He is the person who does that on behalf of the company of which he's chairman.
I mean, that's obviously your case.
Yes.
It's not a distinction.
Yes.
But there you would have an individual who held the right to appoint a majority of the board of the directors of the subsidiary.
For the time being, in his capacity as chairman, is the way we would characterise it. that the right really belongs to the company, and he's the agent of the company for the moment, for the purpose of exercising that right. But it's not his personal asset. And there is quite an interesting point here, Regulation 6.4, which is at page 908. This is in the context of the designation criteria. So Regulation 6 is a very long regulation, which is dealing with who you might or who you have the power to designate, the designation criteria. And Regulation 6.4 on page 908 says, for the purposes of this regulation, being involved in obtaining a benefit from or supporting the government of Russia means, and then there are various elements of that, such as carrying on actually being a government of Russia affiliated entity. And then D is owning or controlling directly or indirectly within the meaning of Regulation 7, or working as a director, whether executive or non-executive, trustee, or other manager, or equivalent of a government of Russia affiliated entity. That seems to suggest very strongly that the draftsman regards being a director or manager as something separate and different from a controller under Regulation 7. So we do say 7.2 is pretty clear on its face, but one needs to also look, as my learned friend has done, at Schedule 1, because Schedule 1 contains provisions applying for the purposes of interpreting the 7.2 text. And Schedule 1 is at 1053, page 1053. Now, to make an obvious point, this is something that is directed to the interpretation of 7.2 rather than being a freestanding test in itself. This is assisting us in interpreting what it means to hold shares, hold voting rights, or hold rights of appointment of directors. That's what it's directed at. And therefore, we would say it is focused, like Schedule 7.2 itself, on the position at shareholder level. And it would be very strange indeed if Schedule 1, which is just meant to go to interpretation, had such a transformative effect on 7.2 that 7.2 suddenly extended to managerial control rather than shareholder owner control. If I could just survey some of the points in Schedule 1. 2 and 3, paragraphs 2 and 3, are relating to joint interests and joint arrangements, and they both use the language of hold or holding shares, as 7.2 itself does. It's not surprising you'd have provisions that deal with that. Paragraph 4 is a provision about calculating shareholding. And it tells you how to calculate more than 50% in certain circumstances. And then 4.2, in relation to a person who does not have a share capital, reference to holding shares in that person is to holding a right or rights to share in the capital, or as the case may be, profits of that person. So again, that's not really surprising. That's directing you to look at the economic ownership of the entity in question. Paragraph 5 then, 5.1 is the provision I alluded to earlier, which is saying that a reference to the voting rights in a person is to the rights conferred on shareholders in respect of their shares. So that's what it's looking at. Or in the case of a person not having a share capital, on members to vote at general meeting with a person on all or substantially all matters. So that confirms we're looking at shareholder voting rights. 7 and 8 then make various points in relation to appointing and removing directors. And 9, paragraph 9 is strongly relied on by the appellants. And the reason for that is this is where this concept of a majority stake, a so-called majority stake, comes in.
Just before you do, coming back to 7, thinking more about this. Is it that improbable that you could give a right to appoint the board to somebody who had no ownership interest?
I could foresee you might have a family member, I suppose, you could give to, but
I mean, you certainly, in the context of trusts, you might well have somebody outside the beneficial ownership structure who had rights. And if you translated that sort of family trust structure into a corporate structure instead, you might easily have someone standing outside ownership.
but in the family example, they're family assets. The personal assets, and it's just the roles are divided up, let's say, where one son is given certain powers to appoint directors, that kind of thing, but they're still family assets. It doesn't have that same character of someone is exercising rights on behalf of the state.
But the patriarch may have set up the family structure with interests in favour of his descendants, but nevertheless wished to keep.
Yes, I'm certainly going to come on to the trust aspect, because that does arise here, as the judge noted, so I'll come on to that. But just dealing with 9, paragraph 9 first. What paragraph 9 is addressed at, as the title says, is shares or rights held indirectly. So it's still using the language of holding shares or rights, but you're holding them indirectly, not directly. And obviously the central case it is addressed to is a chain of companies with a UBO at the top and some underlying assets at the bottom. Anyone drafting sanctions like that would have that kind of situation and scenario very firmly in mind, especially in relation to London properties, other assets in London. So 9.1 is a person holds a share indirectly if the person has a majority stake in another person, and that person holds the shares or is part of a chain, each of which has a majority stake. So it's clearly envisaging the vertical chain of companies. So the question is the effect of this that Vladimir Putin holds the shares in NBT indirectly? One of the questions this gives rise to, and same for Miss Nabulina. Is the effect of this that Miss Nabulina holds the shares in NBT indirectly? And in my submission, it's important not to lose sight of the fact that that is the question we're actually asking under 9. And the appellants can only get this to work by saying that Vladimir Putin or Miss Nabulina are at the top of a chain, top of a vertical chain, and that they have a majority stake in the next entity down, which in turn has a majority stake in the next entity, which in turn leads to NBT at the bottom. They have to get that scenario into this language. And by doing so, they reach the conclusion on their case that Vladimir Putin has a majority stake in the CBR, and then down through the chain, NBT is at the bottom. So it's an essential step in the reading in the case that either Vladimir Putin or Miss Nabulina has a so-called majority stake in the Russian central bank. And that's rather odd, as we've seen, because the federal bank, the Russian central bank, is its capital and assets are under federal ownership, and it is part of the Russian state, as you'd expect. Now, looking at the definition of majority stake, it's in 9.3, and it says, for these purposes, a person A has a majority stake in another person B, and then the first 3 are in the conventional territory of shareholder. You've got holds a majority of the voting rights in B, A is a member of B and has the right of appointment for the majority of the board. C, A is a member of B and controls alone, pursuant to an agreement with other shareholders or members, the majority of the voting rights in B. So that's the conventional territory we've already looked at. But D is what they seize upon, because D is A has the right to exercise or actually exercises dominant influence or control over B. Now, when you read that in the context of everything else we've just looked at, Regulation 7.2 itself and the rest of Schedule 1, it must be directed in my submission to control as owner, as economic owner, or economic beneficiary of the assets. In other words, when it refers to A, it must be talking about A in his personal capacity rather than A in his capacity as a director or manager or state official, i.e. not the kind of control you exercise by virtue of the office or job that you hold at that particular time.
Just going back to our patriarch, he won't be an economic owner or beneficiary. Is he not intended to be caught?
Well, he's the ultimate beneficiary.
Well, he isn't. He's given his assets away entirely, but he still thinks, I'm the person who set up this structure, I'm the person who provided all the money, I'd like to control what goes on.
Yes, I mean, we do say that.
He does.
And he does.
We
because
do
that's
say
how
that
his
person
discretionary
is-
trusts operate.
Yes,
You say that person is caught,
he will be caught by 7.4 certainly.
and I follow that, but that's not because of anything to do with ownership.
Yes. Yes. I'll come on
It's
to that
got
in a bit
nothing to
more
do
detail.
with ownership there.
It's the ultimate enjoyment of the assets, if you like. That they are family assets for the for the benefit of the family. It's quite a different situation to the company or the state situation where one is exercising rights that actually belong to someone else.
I see the point about the company or the state or whatever being different, but it can't be tied to ownership because I'm sure for tax purposes, apart from anything else, it will often be very important that the settlor has no interest in this structure. He has no ownership interest at all, but you accept that he is caught.
That will be caught by 7.4
Yeah.
because it's our submission which the judge agreed with, that 7.4 is the kind of sweeping up of other arrangements that are not specifically caught by 7.2, the backstopping point as you call it. But I'm going to come on to that in a moment. But just to finish on Schedule 1, it would be very strange indeed if this paragraph 9.3d, which we've just looked at, the dominant influence or control, which appears in Schedule 1, completely transformed the nature of 7.2 itself. You start off with a provision in 7.2 which is all about things at shareholder owner level. And it would be very strange if one of the rules of interpretation that tells you what it means to have shares or rights held indirectly, it would be very strange if that rule of interpretation completely transformed the nature of the section so it now applied to managerial control. That would be quite a fundamental change in the nature of what one is talking about. And it would lead to this counterintuitive conclusion that Vladimir Putin has a majority stake in the CBR, which is an extremely surprising use of language, to put it mildly. And it's not a case, you might have other cases where it's all very unclear who owns the entity in question, but we know that the CBR is part of the Russian state. There's no doubt about who stands in the position as owner. So as I say, the way to interpret 9.3d in my submission is that it's referring to a person acting in their personal capacity, as opposed to the control one exercises by virtue of a job, a position, or an office. Now, if one thinks about it as well, I mean, if one is talking about Vladimir Putin holding a majority stake in the CBR, they're saying that not only is that the position, but that Ms. Nabulina simultaneously holds a majority stake in the Russian Central Bank. That is the interpretation they are advancing. And it is a sign that something really has gone wrong in the analysis when neither of those has any personal ownership interest at all. Now the same point about majority stake applies to 9.2, which also uses the same terminology of majority stake. Just pick up now paragraphs 10 and 11 of this. So paragraph 10 is at the bottom of 1055. So clearly nominees have got to be catered for in this. That's obviously got to be catered for. And 10 does that. But 10 is shares held by nominees. So 10 is only dealing with the share holding point, and it obviously makes the obvious point that you can't get around it by using a nominee, but it's only dealing with holding shares. 11 then complements 10, because 11 is dealing with rights held by persons who control their exercise. And by rights, we're obviously talking about the 7.2 rights of the right to vote the shares and the right to appoint or remove the majority of the board. So the way it's structured, it's obviously necessary to have, in my submission, something equivalent to the nominee provision in relation to rights, where you've got one person who appears to hold and control the right to appoint directors, but really there's someone else behind the scenes who's actually controlling that right. It's not surprising you'd want to address that in sections of this type. And what it says is, where a person controls a right, the right is to be treated as held by that person and not by the person who in fact holds the right, unless that person also controls it. So again, looking at my state-owned company example, the rights of appointment of the board don't belong to the minister personally, they belong to the state. The right to vote the shares doesn't belong to the minister personally, it belongs to the state.
Just to be clear, in terms of what you conceded for the purposes of the hearing before the judge, leave aside your capacity point for a moment. Were you conceding that what went on in CBR was such that there was at least an understanding that rights were exercisable only with the concurrence of President Putin or Ms. Nabiulina?
Yes, I can help on that because the concession is actually recorded in the judgment, in my submission accurately, which is core bundle, tab 8, page 185. It's paragraph 202 of the judgment. So the judge at 202 is referring to the evidence, and she's saying all that evidence fell away. And this is all the evidence that there was a political economy expert, for example, who described the nature of Putin's control over various sectors of the Russian economy. There was various Russian law evidence and so on. That fell away in light of the sensible and realistic concession that if control extends to control via office by one means or another, the control test would be satisfied in relation to NBT, at least pursuant to 7.4, in that either Mr. Putin or Ms. Nabiulina could exercise influence or control over it in significant respects, irrespective of whether they've done it in the past. So essentially what we're conceding is that whilst Vladimir Putin is president and whilst Ms. Nabiulina is governor of the central bank, they have the ability to influence the affairs of NBT, de facto. Obviously, if they stopped being president or governor of the central bank, they wouldn't have that anymore. They are, at the moment, they occupy those offices, and therefore they are able to influence the affairs of NBT and cause the affairs of NBT to be conducted in accordance with their wishes. Now, so I've dealt with 7.2, and we do invite you then, as I say, to construe 7.4 in light of what we say is the right construction of 7.2. So going back to Regulation 7 at page 912. So if 7.2 is really directed at shareholder level and ownership, that at least tells one something about how one should go about construing 7.4. But it's absolutely obvious that it is an alternative condition.
But before you get there, as I understand it, you can accept it in relation to 7.2 that it can extend to somebody who isn't a shareholder and has no ownership interest.
Well, I was referring to 7.4 in relation to that.
Oh, I see.
Yes.
I mean, I think, my understanding of what you were submitting a moment ago, I think you may have, because I think we sort of elided or segued into
Yes.
discretionary trusts.
Yes.
But I think if we can go back to, and I lost the page number, Schedule 1, page 1055. I think you were saying that 9.3D is dealing with somebody who exercises dominant influence or control through its holding in A, is that the point?
My submission was that 9.3D is talking about A in his personal capacity.
Yeah.
So in his personal capacity, he has the right to exercise or actually exercises dominant influence or control over a company.
I mean, I follow that. I follow the capacity point, but and I wasn't paying enough attention when you referred to 7.4 before.
Yes, Michael.
Why doesn't that catch the person, the patriarch, who has no interest at all in the corporate structure, but who nevertheless has a dominant influence over it?
Well, the trust structure is more complicated.
Leave
than
aside
that,
the
yes.
trust structure. You've got a settlor who has set up a corporate structure, not a trust structure, but in practice he exercises the dominant influence
Over the top company.
over the top company, or maybe all sorts of other companies, but certainly the top
Yes.
company.
Yes, that
Why is that not within 7.2?
that would be caught. If he, in his personal capacity, actually exercises dominant influence or control over the top company, that would be caught by 7.2.
Yeah.
I think it's my fault. For the trust introduces an extra element of complication because the trust is not the classic chain of
Yes.
See, but that is a very different case to our case, obviously, because it doesn't have the exercising rights on behalf of someone
No,
else.
I absolutely
Yes.
follow that, but that is an instance of it not being tied to an ownership interest.
It's a person who is acting almost with the benefit of the structure or controlling the structure in his personal capacity, yes.
Yes.
Typically by things like family assets. So just going back to 7.4 on page 912. So as I was saying, the first point, we do say 7.4 has to be construed with the correct construction of 7.2 in mind, but obviously 7.4 is intended to add something and is capable of being satisfied when 7.2 itself doesn't apply. That's got to be right. But we do say the judge was right to see this in the context of 7.2, which is directed at ownership, and is sweeping up other cases where the structure may be more complex and not easy to fit precisely into 7.2 as interpreted by Schedule 1. And a complex trust structure is a good example of that. The judge also mentioned Liechtenstein Anstalts and Jersey Foundations, other orphan companies that have no shareholders. There's no end to the complex structures that one could find in the real world. And it's understandable that the draftsman didn't want people to be able to get out of the sanctions on a technicality, if you like. That there's this sweeping up or backstopping of all cases where it's reasonable, having regard to all the circumstances, to expect that P would, if P chose to, be able in most cases or significant respects, by whatever means, whether directly or indirectly, to achieve the result that the affairs of C are conducted in accordance with P's wishes. And we do say it's the same point. It means P in his personal capacity. It's dealing with cases where P in his personal capacity has de facto control over a company that owns valuable assets. And the draftsman wants to capture that.
Can I just try another complication? So I've got my patriarch who's standing outside the structure, who potentially is within 7.2 or 7.4. Now, just to make sure he has some constitutional role, he makes himself chairman. He has the same influence, but he gives himself chairman, the status of chairman, possibly gives himself rights in accordance with the articles of the company to achieve the result he was going to achieve anyway, but now he's chairman. How does it work then?
Well, he's installed himself as chairman. I mean, I think what your lordship is driving at is could one evade the sanctions by giving yourself particular hats to wear?
Yes, I mean, he's doing the same thing, but now he's got a corporate status. Does that mean that he's outside the scope of the regime after all, because he's doing it in the capacity as an officer of the company?
But if it was still a family asset structure, it's still really quite fundamentally different to the state official, in my submission. And I can see that the court would want to look at the reality. It couldn't let someone avoid it just by saying, well, I've now appointed myself as a director, and when I do all these things, I'm acting as a director. But the reality would still be that's a family asset structure for the benefit of the family. And the discretionary trust example came up, and obviously none of the defendants are designated, but it came up because there's a similar fact pattern here, and indeed you've seen we're making a claim in relation to it, where someone has settled assets into a Cayman Islands Star Trust, and we are saying, well, that was all ineffective to part with the beneficial ownership, and you are still actually the owner of the assets in reality because of all these features of the trust deed, or alternatively their transactions defrauding creditors and so on and so on. That's that kind of situation where a complex trust structure has been set up does provide, in my submission, a good example of why you need something like 7.4 and why it has a meaningful role to play. Because those kind of trust structures could own, for example, valuable properties in London, and the intention would be to make sure they are frozen if the family, if you like, actually really exercises control over those properties. For example, they may live in them and pay below market rents and things like that. So it's understandable that that kind of situation would be addressed and would allow a sort of cutting through of complex structures to look at the reality. But of course, what the draftsman couldn't do, no draftsman could have imagined specifically all the different structures that could be devised and try to cater for them expressly. That would be impossible. You need a general series of words that would allow you to capture that. Now, so that's how we would interpret that in a way. If you interpret it as meaning P in his personal capacity, one cuts out state officials exercising state rights or voting with state shares, and one does also cut out directors and managers who are just exercising the company's rights as part of their job. Both of those would be cut out, and that's why we take a different position to that adopted by the judge. We say that they're actually in the same category, and this is all directed at P in his personal capacity, and therefore doesn't apply to state assets or company assets if P is just a director or manager of that company. Now contrast that with the appellant's reading, where 7th law applies generally, including to control that a person has by virtue of their job or their position as a state official. Now we do say that the effect of that reading is stark in the extreme it does seem to mean that all companies in Russia are in fact subject to an asset freeze, even though only about 160 were actually listed at the time of the judgment. I think another 40 or so have been listed since the judgment. So 200 companies listed as a designated person, but if they're right, essentially every company in Russia has in fact had its assets frozen, and it is a crime in this country to deal with those assets or to confer any funds or economic resources on all of those untold thousands of companies. Now, the reason that must follow from their construction is that 7.4 does not require you to show any past control. It just says you could control if you wanted to. So it doesn't require you to prove or doesn't involve any element of a past pattern of behaviour. So for that reason, it seems to follow that Vladimir Putin could, whilst he remains president, exert influence over the affairs of any Russian company. Therefore, they are controlled, and therefore it's a crime to deal with them. They don't really shy away from that, as you've heard. I mean, they seem to openly accept that that is the consequence of their reading of the statute. And it actually goes wider than that, because it covers all Russian companies. It would also, it seems, cover all overseas subsidiaries of Russian companies, because if Putin can control the head company, he could then, if he wished to, control the companies further down in the structure. It would also seem to apply to every overseas company owned by a non-sanctioned Russian individual who lives in Russia. Because once that individual is in Russia, Vladimir Putin could, if he wanted to, exert influence over that person and cause him to conduct the affairs of his companies or their subsidiaries in particular ways. The test would literally seem to be satisfied. It might also apply to Ukrainian companies based in parts of the Ukraine that Russia has occupied, on the basis that Vladimir Putin could influence those companies too. There's no way to limit it on their construction. Once that genie's out of the bottle, there's no sensible limiting principle that they've ever suggested that would stop it applying to all of the things I've just mentioned, with the result that countless thousands of companies that are not listed are in fact indirectly subject to this asset freeze, and it's a serious criminal offence to deal with any of them. Now, the way they respond to that is to say, well, you just have to apply the words as drafted, and without regard to particular decisions about designation that were taken after the regs were implemented. And that's really the point that lies at the heart of their submissions. But the short answer to that is that it's perfectly permissible and right to test rival constructions of language by reference to their effects in the real world. And when you're doing that testing process, it must be right to have regard to all the facts that we now know, including who in fact is listed. Because the effect of their construction right now, given that Vladimir Putin is listed, would be to subject every possible Russian company else to sanctions.
I can't remember, have we been told, is this relatively standard wording across different sanctions regimes?
I've certainly seen it in others, in other regulations. I don't, I can't say comprehensively, but I know it's in others. I think even one in the bundle was too. I think they may have covered that, but it's. But we do say you can test the different constructions by reference to their real world consequences. We've put in the authorities bundle at tab 110 some extracts from Benyon dealing with that point. I mean, I'm sure it's a controversial point in itself, or it shouldn't be. It's at page 5036 of tab 110. I'm not going to go through this in great length, but at page...
Mrs Benyon, is it?
Yes, 5036. You've got regard to be had to consequences. And of course, people do this all the time. In any case about statutory construction, this is one of the staple arguments, that that can't be right because X, Y, Z, and no one says that's an illegitimate argument. It's evaluated along with all the other factors. And then we've also got construction against absurdity at 5060. So we've given the standard that deals with that well-known rule that there's a presumption, not an absolute rule, but a presumption that absurd results not intended.
Yeah.
Now, obviously here we have used the word absurdity, because if they're right, the result really makes a mockery of having a public list of sanctioned companies. It's just pointless, because actually all companies are sanctioned. Whereas there's a very good reason in an asset freezing regime why you'd want to have a list of specific companies that the public can consult and rely on. It's not definitive.
It's never going to be exhaustive.
Exactly.
You're always going to have to investigate the Regulation 7
Yes,
questions,
absolutely.
even in relation to those.
Exactly. But on our construction, the list is at least a meaningful starting point for inquiry. Whereas on their construction, it's meaningless, because every company is sanctioned. I think that's the difference it makes. So for example, let's take a British company that's an overseas subsidiary owned by a Russian company that's not, owned by a Russian company owned by a businessman that's not sanctioned. So the owner in Russia does not appear on the list of designated persons. Someone acting in good faith would consult the list, they'd check the list, and they'd see that the person, the UBO, is not sanctioned, not listed for the asset freeze, and form the reasonable view they could deal with that person, or deal with the company, provided they didn't breach other sanctions. But on the appellant's case, it's a crime to do so.
Unless the businessman was acting as nominee for someone else, or
Yes.
which wouldn't be apparent on the face of the
Yes.
register. So the register is never going to give you
No.
the answer, is it?
No, it's never going to be definitive, but it is, as I say, on our case, it's a meaningful starting point, because people need to know at least how to start their inquiries as to whether they can do a particular piece of business.
I mean, it might be that in a different case, it would be denied that the businessman was susceptible to such influence from President Putin.
Well, he could, I suppose he could say, I wouldn't be influenced if President Putin tried to influence me. But it could be said against that, well, if that actually happened, given the machinery of the state, and that you would be. That's why it does seem to be satisfied in every possible case on their reading. Now, there are further points that tell against their reading in my submission. One of them, and this is quite an important point, is that only the designated person, the person actually on the list, can challenge the application of the asset freezing sanctions. In other words, the designated person can say, I shouldn't be on this list, I've got nothing to do with the war in Ukraine and so on. So they've got that right of challenge, and that's section 23 and 38 of SAMLA, which we did look at the other day, where it's what Mr. Pellet referred to as the ouster clause, where such a person, if they're designated, has got the right to, first of all, challenge the minister's decision to designate them, and then if he's aggrieved with that, he's got the right to go to court for a cut-down version of judicial review, where he can seek to get himself taken off the list. But it's absolutely clear from the provisions that the only people who can avail themselves of that procedure are the actual designated people, and therefore not the controlled people, not the controlled companies. So a further consequence of their construction is that there are these untold legions of companies that don't necessarily have anything to do with the war in Ukraine or the Russian state, but have their assets frozen and can't do anything about it, because they themselves can't challenge designation because they're not designated. The only way those kind of companies could escape from the asset freeze is if Vladimir Putin made a court application under Section 38 of SAMLA, and that's not likely to be a fruitful or meaningful route. So what you have thereby achieved on their construction is in effect a blanket asset freeze of the entire Russian economy rather than a targeted regime based on designating people and companies that are associated with the regime or with the war. And it's obvious when you look at the regulations, they're intended to be the latter rather than the former. As we've seen, certain sanctions, different sanctions, are applied to all Russian companies, but they are different sanctions. They're not the asset freeze, they're the lending sanctions and so on. And that really, logically, that recognises that when you actually freeze someone's assets, you're going a step further than just saying, don't deal with this person anymore, don't do any new business, don't do any new loans with this company. You're going a step further and freezing their assets that they own. And that is explicable on the basis it's a targeted regime that targets people who are associated with the war and the government. Now, the next point is just to emphasise.
And I suppose that just following that through, I mean, there are Russian oligarchs who are not designated persons because, for example, they've stood out against the war in Ukraine. Now, if, for the sake of argument, one of those oligarchs is ultimate beneficial owner of a company in Russia, on the defendant's case, Mr. Putin has control of that company, so that company is designated, even though the ultimate beneficial owner of it isn't.
Yes.
Which does seem somewhat illogical.
Or it could be a company owned by a Swedish businessman.
Yeah, sure.
But because the company and the business is in Russia, President Putin could exert influence over it, and it would be caught on their reading. Now, just to emphasize, the next point is really to emphasise the consequences further, because if they're right, then what has happened is this net of criminal liability has been cast over the entire economy, such that anyone who deals with any of those companies that we've described will commit a serious criminal offence. And of course, the regulations, the offences in the regulations, at least have a mental element. You've got to know or have reason to suppose that you're conferring the funds on a designated person. But the civil penalty element, the civil penalties that can be imposed by the executive, expressly disavow any mental element. Mr. Pillow mentioned this. The relevant provision is at tab 5 of the supplemental authorities bundle. And I should issue a health warning, because this provision is also in the main authorities bundle, but I noticed at the weekend it was the wrong version. So the correct version is in the supplemental authorities bundle at tab 5. And it's the Policing and Crime Act 2017. And it's been amended. So what they do is they expressly say that any mental element is disregarded. That's 1A of the Act at page 166 of the Supplemental Authorities Bundle. And
was there any agreement at the time that the regulations were made?
I'm not sure about that. When this was originally passed in 2017, it didn't have what's now 1A, but I don't know, without checking, but certainly now the position is you can be subjected to £1 million fine or a fine of up to 50% of the estimated value of the funds or resources, even if you've got no guilty state of mind at all.
If that's a 2022 new provision, how does that help us interpret?
Well, it helps.
regulations?
It goes to testing the consequences as to what effect they would have in the world now if they were right. because the effect of their construction is that anyone who dealt with any of the companies in the very wide net would be subject to these fines, even though they're totally innocent and have acted reasonably and without realising what they're doing and so on. And it could be £1 million or 50% of the funds and resources in question. So that those are the stakes, if you like, of the two constructions.
Just to be difficult, I've got a page 167 and I've got a page 168. In fact, I've got a page 165. I haven't got a page 166. If anyone were able at some point to provide me with a page 166,
Sorry about that.
that'd be great.
Page 166 happens to be the relevant page. Now, obviously, because we're in the territory of crimes and strict liability, serious fines, this is where the principle against doubtful penalisation is also relevant, and the judge, rightly in my submission, had regard to that. Now, it's a bit like the debate the other day. Nobody's arguing about whether there is such a principle. It's common ground, there is such a principle. It's referred to in the judgment at paragraphs 223, 226, 235. And 235 in particular refers to the Bogdanich case about the strict construction of penal statutes. Essentially, so people have got fair warning of criminal consequences and can conduct themselves accordingly. And that obviously is also present in Article 7 of the ECHR. So as I say, it's common ground, there is such a principle. The dispute is, well, does that apply or have any relevance here to this question, Regulation 7? And one of their points is there, so well, it doesn't apply because it only applies where there's ambiguity as to the elements of the offence and is unlikely to apply, they say, to a statutory offence. Now, it's important to note how the judge actually dealt with that point, because that is a point they made below, which is at 234 of the judgment, core bundle, tab 8, page 191. So 234 of the judgment, the judge deals with that point. She accepts their submission that one has to be analytical about the approach, must be genuine ambiguity such to lead to uncertainty beyond just disagreement about what the words might mean. Having said that, just because an offence is statutory does not mean that it is incapable of being drafted in uncertain or ambiguous language, either of itself or taken in the context of wider evidence relevant interpretation. Nor do I consider the authorities justify the proposition that the principle is confined to unclarity about the elements of offence or cause of action. Whilst uncertainty of application of principles to a case will not be enough, uncertainty as to the correct meaning of the words expressing an element can be. This is a natural follow-on from the overall exercise which is being performed, ascertaining the intention. Now, of course, the way it arises here is that it is an offence to make funds available to a controlled person. So what controlled person means is that part of the scope of the offence. The wider the concept of control, the wider the offence and the wider the net of criminal liability is cast. So it does go to the heart of what the offence, or one element of the offence, an important element. So would you say the judge was absolutely right to say that when you're construing that kind of language that defines regulation, secondary legislation, where that defines, partly defines the offence, it's obviously right to have regard to the principle against doubtful penalisation when there are two possible constructions, one of which keeps it in what appear to be reasonable bounds, and the other of which has no limit, or virtually no limit.
Have you shifted the point there? Because you're talking about keeping it within bounds, whereas on the face of it, we're talking about certainty. I mean, you could have something that was very, very extensive but certain,
Yes, they're two subtly different points, my lord, I think. Yes, exactly. You could say this is certain because it applies to everyone. But that, it's hard to see that as an argument that fits with the principle truly understood, that it just applies to everyone, so you can't do anything about it. When there's another reading that keeps the offence within sensible bounds.
But even if the other reading is less certain, that's the principle of doubtful penalisation then.
I'm not sure overall, my lord, I'd accept it's less certain overall.
Well, leave aside whether that's this case,
Yeah.
which we may have to come on to. If you have one meaning which is wide and certain, and a contended for narrower meaning which is uncertain, how does the principle support the narrower, uncertain meaning?
It is said by Mr Justice Sales in the Bogdanich case to be a principle of strict construction, and that would point to it being available to keep the statutory offence within reasonable bounds when it's unclear if the drafters of the regulations intended to go beyond that, because the language is capable of more than one reading. So essentially all we're saying about this principle is it is a relevant consideration.
Can I just try one other thing? You in your submissions to us have said, well, there's a distinction between doing things in a personal capacity and doing things in a representative capacity. And I think you'd say, well, that distinction may be difficult to apply in a particular case, but in principle, it's a intelligible distinction. Does that, the judge obviously didn't adopt that approach. She was looking to some category within representative capacity, which one might say was much less certain.
Yes.
So would the principle against doubtful penalisation actually count against the judge's construction, because really she produces a lot of uncertainty?
It might well do. We do not advocate the judge's construction. We've run this as below. Our argument was very clearly it applies to personal assets and not assets that are controlled in the capacity as official or employee or director. That was our argument below. The judge partly accepted it, partly rejected it. We've served a respondent's notice and we continue to maintain that the best reading is personal capacity and therefore personal assets, and therefore it doesn't catch employee control or state official control. We don't advocate that distinction. It's much easier to just say personal assets. And take the example of Gazprom. I can just finish on this point.
Yeah.
I mean, Gazprom is perhaps the most significant Russian company. The fact is, it's not on the asset freeze list. Now, that can't be an oversight. One can only speculate as to the reasons why, but it can't be an oversight. They can't have forgotten about Gazprom. And it's not on the list of designated persons. But the CEO of Gazprom, Mr. Alexei Miller, is a designated person. So how does one interpret that? And we say that it's got to be that the intention and the effect is to freeze his personal assets, but not to freeze all the assets of Gazprom and all its subsidiaries, because if you wanted to do that, you'd simply designate them. And that all works on our reading. Whereas on the judge's distinction, the effect of her distinction seems to be that Gazprom is indirectly sanctioned. And we don't support that or agree with it. Lords, I do have some more. I think we can, but not a great deal more. I think it's agreed that we'll continue after lunchtime to some extent at least. So perhaps we can.
Well, I think that gives Mr. Rabinovitz at least the time that he expected to get, if not slightly more.
Lord, it does. We are going to be tight for time. I'm not, and I may in the end ask your lordships for 15 more minutes. In other words, finishing at 4:30 rather than 4:15. Cutting out, I promise, a lot of the things I could say. So I'm trying to narrow it down very carefully. But even with there are a lot of points in this case. So again, I'm in your lordship, obviously in your lordship's hands.
Well, we say 2 o'clock.
Right.